All right, good morning and welcome to the District of Columbia Court of Appeals. I'm joined this morning by Associate Judge Vijay Shankar and Associate Judge James Kroll, the fourth, who is sitting by designation from the DC Superior Court. We have two cases scheduled this morning, and our first case is Gary Proctor versus US. Are the parties ready to proceed?
I'd like to reserve 3 minutes for rebuttal,
Okay, if you could just state your name for the record.
of course. My name is Lakeisha Mays. I'll be representing Mr. Gary Proctor in this matter.
All right, thank you. All right, you can proceed.
Awesome. Chief Judge, Your Honors, may it please the court. My name is Lakeisha Mays, and I'll be representing Mr. Gary Proctor in this matter. I'm a bit under the weather, so I'll try to enunciate the best as I can. This court should reverse appellant's convictions for the following two reasons. First, the numerous references to Mr. Proctor's prior incarceration violated his presumption of innocence. And second, the trial court abused its discretion in finding Devonshire applicable and admitting highly prejudicial hearsay statements. To my first point, throughout the duration of this trial, there are numerous references to Mr. Proctor's prior incarceration. Starting from the top, the government's first witness on direct examination testifies and says that he met Mr. Proctor when he was released after coming home from being locked up.
Ms. Mays, but wasn't there a stipulation about Mr. Proctor's prior convictions that had been agreed upon and stipulated to in the record? Wouldn't that minimize any potential prejudice of these other statements?
Well, yes, Your Honor, there was a stipulation, and that stipulation was that he was convicted of a crime punishable for a time serving up to a year. The purpose of that stipulation was to mitigate any prejudice. That stipulation doesn't infer that Mr. Proctor actually served time for anything. And so, unfortunately, those references, those prejudicial references, were amplified despite having entered into a stipulation due to these numerous references. So we first have the government's first witness on direct examination testifying after meeting Mr. Proctor. This is a family member. This is a family member stating that he's meeting Mr. Proctor for the first time after he comes home from prison. And that also insinuates that he had not seen him for a while and that Mr. Proctor had served a very long sentence.
But it seems like you have it backwards, because generally the idea behind avoiding references to people having served time is to avoid the suggestion that they had been convicted of a crime that would warrant prison time. And so you don't want that reverse sort of insinuation. And here you're suggesting that the other way around is a problem, when if the jury already knows that he has committed a crime that is punishable by more than a year, it's a felony. So he was at least punishable. I don't see what real difference it makes, or I'll at least put it in terms of prejudice. I don't see what the real prejudice or added prejudice is from the fact that he actually ended up serving time.
Well,
Just the fact that he had committed the crime that warranted serving time.
Well, yes, Your Honor. The stipulation does not state that Mr. Proctor actually served time. And so I would arguably is the difference here. Mr. Proctor, the conviction was supposed to mitigate this prejudicial reference.
Yeah, but what is that? What is that difference? That's what I'm asking. I mean, if he was eligible for serving time, and we know that it would be more than a year because that's a definition of a felony, then what's the added prejudice that he actually ended up serving time?
The added prejudice is that the jury was not aware that Mr. Proctor actually served time for what he was convicted of. So here we have the references that insinuate not only, a served time, but there's that Mr. Proctor was in jail for a long period of time. That stipulation did not speak to the length of time or if any time was served at all. In addition, beyond the first witness, we have the government publishing a photo of Mr. Proctor on a prison yard, in prison clothes, surrounded by other prison inmates, and is a very much noticeably younger Mr. Proctor than the Mr. Proctor sitting at the trial at the time. And you have another reference where the trial court even notices that the clothes he was wearing was, quote, consistent with institutional garb. It's a photo indicating that Mr. Proctor was actually in prison.
Well, there was some question questionability about the clarity of the photo and whether it was clear to everyone that where the photo was taken or what the garb was. Wasn't there?
Initially, Your Honor, but the trial court noted, and this is on Appendix 667, she noticed that it is consistent with institutional garb. And all it would have taken for one jury member to have thought the same, to have looked at that the same, to made the same prejudicial references.
What about the curative instructions that the trial judge offered to provide and were declined by defense counsel at trial?
Your Honor, any potential curative instruction would have brought more harm and more attention to these references, to the fact that this was made public. In fact, it shouldn't have been published at all, but it would have brought more harm. And this court notes that. This court notes that there's a lot of harm that can come from bringing more attention to issues that are already before it, and especially here where you have a photo of Mr. Proctor visibly in prison, where the trial judge even notes that he's in prison garb. As if to make matters worse, there's a third reference. The government's last witness, Ms. Crystal Johnson, testifies that she met Mr. Proctor after he was released from prison. There, the trial court notes that this occurrence was obviously concerning, as this is now the second witness, but yet the third reference that a witness is insinuating having met Mr. Proctor after returning home from prison. These references go beyond simply mentions of a conviction. They present a high risk of prejudice because any juror could have reasonably inferred that Mr. Proctor not only served a long sentence, but a serious crime for that, a serious crime, and had to serve a long sentence for that reason.
How are you getting long sentence from what happened?
Yes, as I'm in the first witness who says this is a family member saying that they're meeting Mr. Proctor for the for the first time. In the record, it indicates that their parents lived across the street from each other. One could infer that it be maybe abnormal that they're meeting each other for the first time, that he's getting out of prison. You visibly see Mr. Proctor, a younger Mr. Proctor by the photo, than the Mr. Proctor sitting during the trial. So it's reasonable to infer that Mr. Proctor had served a long sentence, and we know long sentences are related to serious crimes. So these references are.
And the stipulation, do you happen to have the stipulation language or?
Yes, the stipulation was that it was convicted of a crime punishable for more than a year, or up to a year, excuse me.
I think it would have to be more than a year, right? I mean, it's felon in possession.
Well, and in these references, Your Honor, respectfully, these statements go beyond not having met Mr. Proctor for 12 months. They're meeting him for the first time. Mr. Kevin Diggs, who was the first witness, was 61 at the time when he testified. He's saying at 55 years old in 2013, he's meeting his cousin for the first time. It is reasonable that a juror can infer that Mr. Proctor had served a long sentence, and longer than a year. And we have the language for it, Your Honor. It's punishable by imprisonment for a term exceeding 1 year. And so here, these references, especially individually and taken together, and insinuate that Mr. Proctor had been in prison for a very long time.
I mean, at the end of the day, I mean, your argument, I guess, is that the error was in denying a mistrial.
Yes,
So
Your Honor.
that requires reversal of the conviction, but there's still, the trial court had to engage in the mistrial balancing test with the relevant factors that we've identified before. And you still have to sort of engage in that balancing now. And I mean, I think everyone agreed below, tell me if I'm wrong, that there was no sort of intentional elicitation of these statements by the government. And again, there was an offer of a curative instruction, and I get the defense counsel's reasoning in denying curative instruction at that point, but at the same time, it was offered. And then, you've got sort of the balancing against the other evidence against Mr. Proctor. So tell us where we are on that balancing at the end of the day.
Yeah, well, where we are is, and the record does indicate that, not particularly intentional. These are continuous, and they're throughout the duration of the trial. So much so that towards the end, the prosecutor makes a statement that any prosecutor would know not to make, this suggested burden shifting and this illustrative narrative of a seesaw and the balances of justice scales, insinuating that Mr. Proctor had a
I
burden
mean,
to prove.
you're getting into other issues now, which seems, maybe you're making a cumulative error argument. I don't know if that's what you're making. I'm not sure it was explicitly made in your brief, but maybe I'm wrong about that. But, you know, just with respect to the references to prison time and the balancing of the factors as to whether a mistrial is required, that's kind of what I'm getting at more specifically.
It's a pretty high standard too, with respect to the grant of a mistrial.
Well, yes, Your Honor. Here, this constitutional error here is the pure, simple fact that Mr. Proctor's presumption of innocence is violated. There is purely enough inference that can be drawn from these statements that would prove that these references to his prior incarceration show that Mr. Proctor had reasonably been in prison for a very long time.
The constitutional error you're referring to is what you call the seesaw, or not you called, but the reference by the prosecutor to the seesaw analogy. Is that the constitutional error that?
The constitutional error is the prejudicial references in these statements by the witnesses and the photo. And that is the harmless beyond a reasonable doubt here. With the photo, the trial court, court's indulgence. The seesaw analogy, the trial court had a responsibility there and to provide an actual curative instruction that would have righted that wrong that the prosecutor.
Was a curative instruction requested at that juncture? Are you saying the trial court should have sua sponte issued a curative order when the prosecutor made the statements about seeming to insinuate that the defendant had some burden?
Absolutely, Your Honor. In fact, the trial court noted after the rebuttal argument, this is after trial counsel is not even able to respond at this time, but the trial court noted after these comments were made, after trial counsel objected to the seesaw analogy, that she even found that analogy concerning the first time that she heard it. And so the trial court could have sua sponte.
But was a curative instruction requested at that juncture? I know it was during rebuttal, but there still was an opportunity. The defense counsel did object, but did not request the curative instruction at that juncture.
Well, the curative instruction that was provided by the court was a standard instruction. It didn't address the seesaw analogy that the government illustrated during its rebuttal argument. And so
did defense counsel request a specific curative instruction about the seesaw analogy at that juncture?
No, Your Honor. In fact, the court, Mr. Proctor's counsel renewed its motion for a mistrial after hearing such analogy, and the trial court's decision was to provide a standard instruction. However, we know curative instructions have to speak to what needs to be cured. A standard instruction did not provide any instruction as to the actual seesaw illustration itself, which were made twice. The judicial scale, which were also made twice. The standard instruction did not speak to those references alone. It was just a standard.
Why didn't it? The issue is burden of proof. That was the basis of the objection at the time, was that it was inappropriate burden shifting. And here the trial court at the voir dire, pre-opening, post-closing, pre-closing and post-closing, 4 times gave the burden of proof instruction. Why wasn't that in and of itself curative and directly on point as to the alleged error that you know?
Yeah, well, Your Honor, when the government goes, there's a 10-year-old on one side and a 2-year-old on the other. It's insinuating that there's this presumption of, this production of evidence that Mr. Proctor has to weigh. That is starkly different from what the standard instruction or what any juror should be considering at that time. And so while, early in voir dire and the standard instructions, they are told the accurate instruction. Here, that illustration insinuates that Mr. Proctor is supposed to overcome the size of a 10-year-old, and it's arguably the 2-year-old on the other side, and that's incorrect.
And why wasn't it corrected by giving the proper instruction of the burden of proof? To the chief's point, The issue at hand was burden of proof. There was no contemporaneous objection, no request for a curative instruction. Therefore, the trial court, why was it improper for the trial court to give that which it did, which was the burden of proof standard for a fourth time? Why did that not cure the alleged error?
It did not cure it because it did not speak to what was wrong with the illustration. It was just another standard instruction, but it did not specifically address the inferences that were made from that illustration.
So your position is that the curative instruction needs to be on point as to the specific metaphor or misstatement.
That definitely would have helped, Your Honor. And instead, it was a standard
Can you decide
instruction.
whether it would be of help? Is that legally required?
Well, in order to be curative, you do have to address the wrong, the faults that were there, and this simply did not. It just reiterated the standard. And if, you know, and maybe the government should have reiterated the standard instead. It drew this illusory image of a burden that Mr. Proctor wasn't required to produce. And so the instruction should have matched that. And because it didn't, these errors, cumulative, were grave and caused prejudicial harm to Mr. Proctor.
Okay, we'll give you a couple of extra minutes because I did want to hear your argument with respect to the Devonshire.
Absolutely, Your Honor. To my second point, the government's third-party beneficiary, Devonshire theory, was unsupported and unreasonable. There was no corroborating evidence to support this third-party Devonshire theory.
Well, if we accept the dying declarations of, I'm getting the names confused, Mr. Diggs, the decedent who told several people as he was dying after being shot that Mr. Proctor did it, or little Gary, Mr. Proctor, because he wouldn't, and I'm paraphrasing, because Diggs would not agree not to testify against Proctor's father. So those are pretty compelling statements. And I know you have an argument that they shouldn't be admitted because they were hearsay, but assuming they were correctly admitted, why wouldn't Devonshire apply here?
Well, speaking to that, the evidence particularly, these statements were being made in a particularly unique time. Mr. Diggs is at a loss of a large amount of blood. The record indicates that he had several drugs and alcohol in his system, K2, along with other levels of drugs and alcohol. And there are two references here. He says Gary, and then in another instance, he says little Gary, and then in another instance, he says little man. But what's important with Devonshire is this intent, right? This intent to make a witness unavailable to prevent them from testifying at trial here. And there has to be some evidence to corroborate this intent. These statements alone that Miss Offutt makes that Mr. Proctor allegedly told corroborated by anything else in the record. They're standalone and they're bootstrapped in order to bolster the government's motive in their theory here.
Well, I get that argument, but if we were to disagree and presume that these were properly admitted as dying declarations and therefore not hearsay, under Devonshire, have the requirements been met? Here, Mr. Diggs was supposed to testify in the CPO, Civil Protection Order hearing for Gary Proctor's father in a against Gary Proctor's father in a domestic violence case. And if we credit the statements of Mr. Diggs that he's being shot because Gary Proctor, the defendant, didn't want him to testify against his father, is that sufficient under Devonshire to come into this forfeiture by wrongdoing provision?
No, Your Honor. In fact, as a matter of law, Devonshire applies when a defendant makes a witness unavailable, and that witness is a potential or actual witness against the defendant.
Don't we have some cases though where we've extended it a little bit? I think it's either Ward or Harrison, where this court has said it didn't necessarily have to be against the person who eliminated the witness themselves.
So it's kind of a two-parted here. In terms of Devonshire as a matter of law, the witness has to be testifying against the defendant. Here, as you mentioned, and as in the record, you see that the trial court misunderstood some of the CPO proceedings. Mr. Diggs would have allegedly testified in support of Ms. Diane Offutt, and it was Mr. Proctor's father, Gary Offutt, who filed the CPO proceeding. The trial court's determination would have been limited solely to whether Ms. Diane Offutt intended or committed a crime here. And so with this instance, and as a matter of law, Mr. Diggs was not a witness against Mr. Proctor. He may have been a witness against Mr. Gary Offutt, but it was not Mr. Proctor. In fact, to the cases that you referenced in Ward, the defendant knew, the witness in that case told others that she saw the defendant kill the decedent, and that defendant followed her to the police station. The defendant knew that this person was aware and would have served as a potential witness as she had been cooperating with the police. In Jenkins, we have something similar where the defendant is aware that the witness would have testified because they testified at a grand jury proceeding. And also in
But wouldn't the testimony, counsel, wouldn't the testimony have implicated little Gary as well? The cookout fight allegations are that both Big Gary and Little Gary attacked not only Mrs. Offutt's son, but Diggs himself. Wouldn't that have been and potentially placed Little Gary in potential criminal liability and standing alone, irrespective of how it might have implicated Big Gary's interest?
Your Honor, the third party Devonshire theory is unreasonable for a number of reasons. The police were called to the cookout. If they and were called to the cookout, there were no investigations subsequent of the cookout. There were no pending warrants, arrests. There was no follow-up. Ms. Diane Offutt testified that the police.
The standard is preponderance, and the trial court had to find by a preponderance whether or not, correct?
Yes, Your Honor. And the government's theory is that Mr. Proctor would have committed a crime against a relative simply to prevent him from testifying in a CPO proceeding based on threatening text messages. That does not meet that standard, Your Honor. If Mr. Proctor or his father wanted to prevent Mr. Diggs from testifying, Mr. Gary Offutt is the petitioner. He could have dismissed the petition himself. So this third-party beneficiary theory that the government solely relied on with these hearsay statements is unreasonable. It's unreasonable to presume that Mr. Proctor had a fear of any incriminating statement that would have came as a result of Mr. Diggs allegedly testifying about an events of a cookout, which are unrelated to the CPO proceeding, which are about text messages. But that anything would have came from that cookout that the police weren't not already aware of and showed no intent, especially in the record.
So your point is that what we have here is much more attenuated on a number of different fronts than the typical case where the Devonshire evidence would be.
Absolutely, Your Honor. In fact, in Devonshire here, one of the assailants learned that the witness was cooperating with the police. As a matter of law, Mr. Diggs was not a witness against Mr. Proctor. And that is why this Devonshire theory, this Devonshire theory that the government is solely relying on this mode of evidence is just unreasonable. It's theory that Mr. Proctor and the facts that the trial court and made these findings in, the motive is just too unattenuated that Devonshire would be applied in this stance.
All right, thank you, counsel. We'll reserve your time for rebuttal as well.
Thank you.
Good morning, Your Honors. May it please the court. Michael McGovern on behalf of Appellee of the United States.
All right, good morning.
I'd like to pick up where opposing counsel left off. That was with Devonshire. I think there's been an implication that it was somehow unreasonable for the trial court to find that it was more likely than not that the purpose behind the killing of Mr. Diggs was to prevent him from testifying at the CPO hearing between Mr. Gary Offutt and Miss Diane Offutt.
It is a bit of a Venn diagram when you try to figure out who going to testify against who, about what, and what might have been damaging. And it is a bit more attenuated than than Devonshire, the facts in Devonshire itself. Can you walk us through how this maps on to a typical Devonshire
Absolutely.
evidentiary issue?
So with the Devonshire evidentiary issue, what we need to show is one, that the person against whom these statements are being admitted either was directly responsible or had aided and abetted or in some way was responsible for making the witness whose testimony wants to be used unavailable.
So how is
The evi-
Diggs's testimony going to be harmful to Gary Proctor, the defendant here? That was the first prong that you just stated.
Sure. So the evidence that it was going to be harmful was the trial court's recognition that what was at stake with respect to the testimony that Diggs would have given at the hearing was that at the barbecue, both Gary Offit, the father, and Gary Proctor, the son, were involved in an assault that would have been a felonious assault, which would involve jail time, which would be a serious criminal incident.
But what's the theory? So Mr. Diggs testifies at the CPO hearing to, on behalf of Miss Offit to prevent the CPO from being issued against her. And his testimony is, well, there was this big fight and Big Gary and Little Gary beat up so-and-so and so-and-so. So, she was not at fault. She was trying to do X, Y, and Z. Okay. The notion is that the trial court at that point has to make some sort of, or the prosecutor has to make some sort of criminal referral based on that in-court testimony that Mr. Proctor has to be picked up at this point based on this in-court testimony that points out that a fight happened 2 weeks earlier.
I don't think that has to be shown. I think what needs to be shown for the Devonshire exception to apply is that the reason that that Proctor killed Diggs was to prevent this testimony from coming out. Regardless of why in particular he believed it would be damning, we believe that the record shows the reason he believed it would be damning is because it implicated him in a felonious assault, that it implicated both him and his father, and that he wanted, but to the extent that he committed the murder because he wanted to prevent the testimony because it would have prevented his father from actually achieving the goals of the CPO. Preventing the goals of the CPO and eliminating the testimony to that was upheld as a basis for Devonshire to apply in Hairston. So it's not that there has to be a criminal, the only purpose is a purpose to kill someone to prevent their testimony in a criminal case. It's never, Devonshire has never been restricted by this court to that.
So that, I guess
purpose.
that's what I think is much more plausible argument, which is that he's supporting his dad and he doesn't want this CPO or he's got a beef against Miss Offit. So he well, now I'm getting everything backwards. He doesn't want Mr. Proctor supporting his dad. He doesn't want the CPO issued against him. So and he's got a beef with Miss Offit, so he wants to kill Mr. Diggs to prevent him from testifying effectively against his dad. Forget criminal implications, forget implications against Mr. Proctor himself. That seems like the most plausible theory to me. And I'm asking if that, in your position is that would satisfy Devonshire.
That's correct. And I think if you look at the fact that in Hairston, it was the prevention of testimony at a CPO hearing that was the substance of the murder and the reason for the murder. So you have it removed from a criminal case in that case. And then you also have this court's decision in Ward in which Thompson committed a killing on behalf of another individual, which was Ward himself. It was a co-defendant case when it was tried, but the reason Thompson was on trial was because he had killed a witness to the prior murder that Ward had been charged with. So Thompson was killing a witness for the benefit of someone else.
But we haven't had Hairston plus Ward, right? Basically, this is Hairston plus Ward. And we would be having to extend Hairston and Ward by combining them.
I don't believe that would be an extension. I think it's correct that this is both the concepts from Harrison and Ward together. But there's the legal bases on which both Harrison and Ward were decided don't have a reason why they wouldn't be read in tandem. They're not in conflict, and there's no reason not to read the legal principles individually. So at step one, we ask, was the purpose to kill someone who was a witness? And the answer is yes. This individual was going to be a witness. And although it was a witness at a civil proceeding, this court has already said that Devonshire applies when you kill witnesses to civil proceedings. And then we ask, I'm sorry, I lost train of my thought there.
Then you asked the question from Ward. Then you
Yes, the
asked-
question from Ward, which was, well, what if you weren't a party, right? What if you don't have an interest directly in necessarily the particular?
It's not interest, it's damage. That's the word that Giles uses. That's the word that's used. But the following is that it has to be damaging to those interests. It's linked to here. The damage, as you articulate, is that it would be damaging to Big Gary and perhaps Little Gary, the testimony that Diggs were to proffer. But here, the person seeking the CPO is Big Gary. That's in opposite to the facts that we had in Harrison and Ward, right? Because the person with the movement in the underlying civil case, it could simply dismiss the case if they didn't want that testimony to come out. Why is that not? Why doesn't that change the analysis? It gets more and more attenuated, right? Because the damaging to who? And is it the individual here, Diggs, that is providing that testimony? It's damaging to ostensibly Big Gary, but also Little Gary. It keeps getting further and further out as to who it's connected to and the linkages between the intent, the specific intent announced in Giles and in the commentary to the federal rule that articulates what that specific intent. The specific intent here, how do you define it based on the facts below?
So I think the specific intent here is to eliminate a witness for whatever purpose. And in this case, it was to protect his father. But the purpose of
for whatever purpose. So that's the point, is it has to be, and that's what Giles announces, is that it's to prevent the testimony that is damaging, right? That otherwise damages the individual. It's not just eliminating a witness in the ethosphere. There's a purpose to it.
yes, but what I would note is that this is no further attenuated than a prototypical Devonshire case where someone eliminated a witness against themselves. When someone is, say, facing their own case and a witness against them is eliminated, they have a witness eliminated against them. This court has found we can introduce that testimony at the case in which, right, the witness was previously going to appear. That actually is the remedy for the wrongdoing as to what you were trying to prevent, their testimony at that first. But then also we allow that testimony to be used against that defendant in the proceeding that deals with the obtaining of their absence itself, the wrongdoing itself, which is what we have here. In the case where we are prosecuting you for the actual wrongdoing that made them unavailable, we're also not going to let you profit from your having killed them because they were a witness. And that's because, as this court has recognized, what's really underlying the Devonshire exception as a hearsay rule here is the court's ability to protect the integrity of its proceedings. And that remains the same whether the witness was a witness in the particular defendant on trial here's case or anyone else's
But
case.
suppose, I mean, I think this is a follow-on on Judge Kroll's question, but I mean, if someone could potentially testify against you at a criminal trial, but you have all sorts of other reasons to want to kill them. They owe you money, they, engaged in an extramarital affair with your spouse, whatever it is, and you kill them. Are you saying that the theory behind Devonshire is you should never be able to profit from that period, and so procuring their unavailability cuts against you at a later proceeding without any indication? Well, I guess in that situation, because all we ask for is one of the reasons is to procure their unavailability. But suppose there's no, suppose you have no idea that they're going to testify against you at a trial. Your killing of them is, we can pinpoint it to some completely different reason. Is it the policy, are you relying entirely on the policy behind Devonshire, which is you should not be able to benefit from their unavailability, which you caused?
No, I believe no, Your Honor, and I think if I can take that question.
It was a very bad question.
My understanding is the question is, if one didn't know they were going to be a witness, and that didn't form the purpose of why they killed you, then no, Devonshire would not apply. Giles is very clear on that. But I think the question is, if there is a civil case where the defendant chooses to eliminate a plaintiff's witness and does so, if that defendant is then tried criminally for eliminating that plaintiff's witness, can we use that plaintiff's witness in the criminal testimony in the criminal case? Well, certainly it likely will be relevant to motive and likely will come in. Now, the purpose was not to prevent that plaintiff's witness from testifying in the future criminal case, but the application of Devonshire would be appropriate. And we see that in these cases like Ward, where we have Thompson killing an individual for the purpose of an unrelated criminal, a criminal case that is not his. So he's doing it on behalf of someone else. Yet when he comes to trial for that killing, we allow Thompson to be confronted with and have admitted against him the statements of the witness he killed to prevent that witness's testimony in Ward's prior case. So I don't think that we are extending this any further. Now, there may be interesting questions about what limitations need to be placed on it, but at the very least, we know the two places we should allow the forfeiture doctrine to occur are the case in which the witness was going to testify because they've now been made unavailable. In order to do that, you need to show that the party who is in that case is the one that procured it, right? If someone unbeknownst to you went out and killed a witness, you shouldn't be held to a forfeiture doctrine because of that. But if it was you, then it can be used against you in that prior proceeding. And then if there is a proceeding relating to your obtaining their absence through wrongdoing, it should be, Devonshire should apply as well.
Can I take you back very briefly to, I guess, the preliminary issue of the statements that were made.
Yes, Your Honor.
We've been talking about Devonshire, presuming that the statements of Mr. Diggs as he was dying were admissible. Appellant's counsel argues that there were problems with those statements, that he may have been, apart from dying under the influence of drugs, and that there was no corroboration to those statements. Don't we have to assess? We just don't assume or presume automatically that statements made by a dying person are admissible hearsay, do we?
So I'd like to sort of break that apart twice. In answer to your final question, no, we don't automatically assume that all dying declarations are admissible. There are certain evidentiary standards that we use to determine whether or not they believe they were under an impending fear of death before we can put them in. But with respect to the evidence that the government was relying on in order to establish the preponderance of the evidence in order the pre-admissibility of decision, the statements that Proctor had confronted Diggs were not actually contained in the dying declaration. So I want to make sure that that's very clear. What occurred was days prior to the shooting, which would be days prior to the dying declaration as well, Gary Proctor had approached Diggs and while he was with his girlfriend and had offered them both money not to attend. And so it was those statements that were brought in through Diane. So they were hearsay because the only reason we had access to the statements that this occurred was because we had Diane's testimony that her brother told her this. But this court has found in Jenkins that you can use hearsay when evaluating pre-admissibility. And to the bootstrapping issue, this wasn't the only evidence that the government presented here. We weren't relying solely on Gary Proctor's statements to Diggs as related by Diane to the court. We were relying as well on the timing of the CPO, the timing of the killing in relationship to the CPO, to the interests that were at stake, the fact that there was a reason to believe that the testimony that Diggs was going to give was not just going to prevent his father from getting a CPO, but was very damaging to both him and his father as to felony assaults that had occurred. And so when you look at the stakes that were at issue with respect to the testimony Diggs was anticipated to give, when you look at the timing, and then when you look at the fact that there was a prior time at which Proctor himself told Diggs he didn't want him, that he had an interest in Diggs not attending that, all of that together managed to come to a preponderance of the evidence that the purpose behind, one of the purposes behind killing Diggs was in order to prevent his testimony at that CPO hearing.
And you have Diggs's statements. Weren't some of his
Diggs's statements to Diane, yes. So
over the telephone as he's died?
He did not mention the CPO hearings or his being a witness during the dying declaration. So
what he does say is that little Gary, little man, presuming that that was Gary Proctor.
yes,
shot him.
sort of as a background to all of this, there must be a showing that it was Gary Proctor who killed or procured the absence of Diggs. And so certainly the government presented all of the evidence that was going to present at trial and then was presented at trial, the very strong evidence that in fact it was Gary Proctor who killed Diggs. So the identity of the killing was a matter that had to be established, and that was established not only by the excited utterances, but by an eyewitness who saw Gary Proctor leaving the house.
Not only by the dying declarations, you mean, of
the dying declarations establishing the identity of who did actually commit the murder, yes. But even if this court were to find that the evidence was too attenuated to say this is definitely or this is probably a reason that you killed him, to the extent that that is so weak that it doesn't form a likelihood that this was the base of his motive, there's no prejudice to the introduction of these Devonshire statements, because the jury simply wouldn't have believed that that was a viable motive and would have moved on and would have gone to the more damaging testimony regarding the dying declarations, the corroboration by physical evidence and such.
I mean, it's not before any of us here, and I know you didn't handle, it just seems like an odd choice when you've got two other motives, government's theory, and you don't have to establish motive to push this line of Devonshire and create a potential, reversible error. And I'm not saying we're there, don't get me wrong, but it just seems like an odd strategic choice.
So I think
But that's not before us, but you're welcome to answer that, but you don't have to.
I think I will say that there was a lot of discussion about what information about the CPO and about the barbecue was going to come in. And there were a lot of discussions about what was permissibly admissible and what could permissibly be rebuttal evidence to that. So the parties were jockeying very much around what was going to come in and what was not. To the extent that the CPO was going to come in, I think the government thought that it was fair to show to the jury that this is a motive, an additional motive as to why he killed him. There was, to the extent that the jury has now heard there was this fight at a barbecue and has now heard that there were CPO proceedings that were ongoing with respect to one of our witnesses, you should know that those ongoing CPO proceedings were one of the reasons that Gary Proctor had to kill this man. So I think there were many issues at play, and there was a lot of balancing and strategic decisions to be made. At the end of the day, again, I think even if you thought that it legally was or that there was no basis for the Devonshire exception, that it would be harmless in any event. I say I'm out of time. I'm happy to address the references to incarceration. I think I would simply defer to any of your questions.
I guess what's most concerning were some of the statements made in the government's rebuttal that go to the burden of proof and how the jury should weigh the evidence.
So I think there, Your Honor, what's important to note is that the trial court believed that there had been the potential that there had been possibly an implication that the manner in which this analogy had been used could have resulted in someone believing the burden of shifted.
Aren't you in the position of at least agree? The metaphor was not only inaccurate, it was inappropriate. It is shifting the burden. First off, the way in which the prosecutor defined the use of the scales of justice is inaccurate. That's not what the scales of justice mean. And then separately, shifting and calling it a seesaw and using a metaphor as a seesaw and that there are weighted pieces to that, doesn't that in and of itself shift the burden after having had 3 separate prejudicial incidences during the government's case in chief? You've got a comment about him being in jail. Another witness says that he was in jail. And then you have a picture of him in jail. And then you talk about that the burden ostensibly is suddenly shifted over, at least in part, to the defense. Why isn't that in and of itself a basis to reverse?
So, Your Honor, I think I will agree that it was an inaccurate and an ill-advised analogy. I think when one looks at the way in which it arose, what the government was asking primarily the jury to do, and its focus at that point was on the weight of the government's evidence and also acknowledging that the government had its burden. I'm not saying that this is an appropriate analogy, and certainly the trial court thought this invites the jury to require the defendant to produce some evidence, which is wrong, right? That this is an inaccurate statement of the law or an inaccurate implication of what should occur. But recognizing that, at the first moment that it is addressed by any of the parties, decides that it will give a curative instruction, which explicitly, as Your Honor earlier noted, went to exactly the harm that was the issue with the metaphor. And that is, what is the burden of proof? And it squarely informed the jurors that the defendant has no burden of production and has no burden of proof here. And in light of the many repeated statements of that legal concept, which had happened since the inception of the trial. This includes voir dire. I think, as Your Honor indicated, it had occurred at voir dire. It had occurred during preliminary instructions. It had occurred in instructions prior to closing arguments. It was a statement that was made by defense counsel in closing arguments. The government's burden and the government bearing the burden was something that the government actually opened on in its rebuttal. So the jury was repeatedly advised as to where the appropriate burden of proof lay and that the defendant had no obligation to present any evidence. And so the trial court at that point had a decision. Do I have to declare a mistrial? Is there no choice but for me to declare a mistrial, or do I have something else at my disposal to deal with this potential prejudice? And what it chose to do was reasonable and was a reasonable exercise of its discretion, which is I am going to remind the jurors, and it actually in the re-instruction refers the jurors back to her prior instructions, right? As I previously instructed you, and then talks about the burden of proof and the fact that there is no burden of production. So there was no requirement for a mistrial here. With respect to, I'd just like to briefly push back, if I may, on your characterization and opposing counsel's characterization of the photograph clearly depicting him in prison. There's a copy of that photograph in the record. We supplemented the record with that. I think as the trial court said, when it was displayed, it did not, in the brief moments that it was displayed, think that it was a picture of anyone in prison or would have had that impression. And it was only upon examining the picture, the trial court then was looking outside of the presence of the jury, was looking very closely at the picture and said, oh, I'm familiar with institutional garb, and I can see how someone who also is familiar with institutional garb may, upon close inspection of this photograph, think so. And the parties didn't send the photograph back. The jury simply didn't have it during its deliberations. So the only exposure that the jury had was to the very brief, and in the transcript, it takes up less than half a page, which I imagine is going to be, I don't know that I can tell you what the exact time period was, but it would have been fleeting. It would have been very short. And similarly, the references to prior incarceration by the two witnesses were very fleeting, very short. They didn't indicate why he was arrested. They didn't indicate that he was actually although one said in prison, the other said locked up, which doesn't refer to whether or not there were actual criminal charges that had been pressed or actually that he had been convicted. And here I think it's important to return to what Judge Shanker noted, which is the harm that we see there is that someone is going to think because of someone's prior criminal record, they have this criminality and they're going to base their decision on that. And there's simply no danger of that here. They were informed that he had previously been convicted. They were informed of how they could make use of that information. When witnesses were impeached by their own convictions, they were repeatedly informed that that could only be used to go to their credibility. And there was simply a very strong case here outside of those references to believe that it was the drug dealing that they knew about. It was the drug dealing relationship between these individuals that the jury was focused on, which led to the shooting.
Great. Thank you, counsel.
Thank you.
All right, Ms. Mays, you have a few minutes for rebuttal.
Thank you, Your Honor. There was a lot covered, but so I'm happy to address anything specifically that the court would like to address. But I would like to start off with Jenkins. Opposing counsel mentions that these statements are sufficient on their own. However, in Jenkins footnote 43, it specifically states that corroborating evidence must accompany hearsay statements. And this is just another example of the government's attempted bootstrapping to get this hearsay statement evidence.
Now, which hearsay statements? Sisters hearsay statements or the decedent's?
The
statements?
sister's hearsay statements about Mr. Proctor allegedly seeking to prevent Mr. Diggs from testifying. There's no corroborating evidence, and that's exactly what Jenkins requires. And so definitely wanted to highlight that to the court because that is important. It's not just the hearsay statements themselves that are sufficient. It has to have corroborating evidence, which this record does not have. It's empty of anything to corroborate these statements other than Diane Offit's hearsay statements. The proffer relies on that solely, and the motive in this case is central to its entire theory here that Mr. Proctor, it's how they create the intent for Devonshire. These statements alone with no other corroborating evidence. Additionally, the Devonshire exception is not boundless. There are bounds to Devonshire. And even in the government's brief on page 21 cites Roberson, which says it's the right to be confronted, right to confront a witness against him. The witness has to be against the defendant. That is our forfeiture by wrongdoing cases. That is how this court has looked at forfeiture by wrongdoing cases. And that is what is required. Mr. Proctor.
Well, Ward, the witness wasn't against the person who actually killed him.
Yeah, well, yes. In Ward, the decedent saw that the decedent saw that the defendant committed the crime and was cooperating with the police, but the defendant knew that the decedent was cooperating with the police. She could have been a potential witness. And so I misspoke. It's actual or potential witness. And there's no evidence in the record that Mr. Diggs was an actual or potential witness. So if I may clear up the trial court's misunderstandings of the CPO proceeding, and I understand that Judge Krall is a bit familiar with them, but the trial court's findings were rooted in the fact that this was an alleged assault based on the eligible for some sort of felony conduct. Text messages, threatening text messages, albeit harmful, are not eligible for some sort of felony conduct. The trial judge misunderstood the proceedings and the parties here, which are that Mr. Gary Offit, Mr. Proctor's father, was the one that submitted the petition to prevent Miss Offit, his sister, or his cousin, excuse me, a lot of the parties are related, to prevent them from prevent her from continuing to send text messages here. And so going to this third party theory, this notion that Mr. Proctor would do something as heinous as the government describes to prevent Mr. Diggs from testifying about something that the police already know is unreasonable. It's blatantly unreasonable. And here, any insinuation that there's potential criminal investigations, criminal actions that would have taken place from it, and that fear drove this, it's an unreasonable theory, Your Honor. Additionally, what we would like to also draw attention to is the cumulative errors that are present here. So the presumption of independently and taken together. We have these references that are made by the government's direct witnesses, their first
Did you make
With,
the cumulative error argument in briefing?
yes, Your Honor, in our reply brief. We have not, individually and taken together, we have these prejudicial references. We have this rebuttal argument that our trial counsel doesn't have an opportunity to respond to. We have these bootstrap hearsay statements and taking all into account, it paints a nefarious light over the evidence in this case. And it's not unreasonable to think that a juror could have also looked at these references over time and shaped whatever theory or whatever conclusion in light of this nefarious imagery that the government showed in its case. These errors were really, these errors are serious, and as a result, we see the impact of that. If there are no further questions, Your Honor, I will state that our foregoing reasons, and we ask this court to find in favor of the appellant.
Great, thank you. Great. Court would like to thank both counsel for your briefs and arguments in this case, and the matter will be submitted. Our second case is 4022 Georgia Avenue LLC versus DC Department of Buildings. I'm wondering if you have everything you need there. It's a lot of documentation in the case there. Counsel, are you ready to proceed?
Good morning, and may it please the court. My name is Mark Crawford, and I represent 4022 Georgia Avenue LLC. Petitioner in this case, respondent on the order to correct that is at issue from the agency decision below.
Did you want to reserve a couple minutes for
I'd like
your
to reserve
rebuttal?
3 minutes, yes.
All
please.
right, thank you.
Thank you. Your Honor, we're before the court on an order to correct that was issued by what was then Department of Consumer Regulatory Affairs, DCRA, on December 2nd, 2021, to two entities, my client and another entity called DV Investments. And it was not issued to the owners of the property located at 4022 Georgia Avenue Northwest. And there is a timely appeal by what I'll call 4022 LLC for brevity's sake. There is a hearing that eventually follows. The appeal was December 16th, 2021. The hearing before OAH was April 8th and 9th of 2024.
Mr. Crawford, can I kind of cut to the crux of at least my question
Of
here?
course, Your Honor.
Is it your position that an order to correct must necessarily, in all cases, include the owners of the property, or must do so at least in cases where a permit is required to make the corrections? Or is at least required where the facts known to the agency, the Department of Buildings, suggest that the owners might not cooperate in the abatement efforts?
Yes, Your Honor, that is certainly our position.
Well, I'm
absolutely.
sorry, I had
don't-
I had a couple ors in there, so which one is?
I will, well, I don't know that the court has to reach the question of whether every order to correct issued by DCRA, now DOB, must be served upon the owner. But in any instance where a building permit is required, then certainly that is necessary, whether it's under, whether you're talking about under the 2013 version of the building code, or the version of the code in effect now, because the work, if an order to correct directs the respondent to perform work, the respondent cannot perform that work. If a permit is required, the respondent cannot obtain a permit to perform that work.
Well, these orders to correct, was just checking with the regulations. The regulations authorize OAH to issue orders to correct to owners, operators, occupants, or other persons responsible for the unlawful condition. And the work that often needs to be done to correct a violation very often requires obtaining permits of various kinds. And so I guess where we are in the process of 4022 challenging the issuance of the order to correct, it seems that OAH's decision and denial of that challenge is based on, I guess, the procedure and the procedural posture of the case. They're essentially saying that, it's premature to challenge the issuance of the order. That perhaps down the road where it can be demonstrated that efforts have been made and then thwarted by the actual owners, permits have not been able to be obtained after due diligence, that these may be viable defenses. But I read OAH's order and decision as saying at this juncture, this is premature. Almost, maybe it's not an exact analogy, but we're sort of at the motion to dismiss stage very early in the proceedings, where not enough time is or basis for showing that the order to correct in itself was issued in error, when the regulations say it can be issued against various people. It doesn't have to be issued against the owner or occupant alone.
I agree that is the way that the OAH final order reads, but I submit to the court that is, pardon me, that is an error committed by OAH, because if an order is legally flawed, if the flawed nature of the order is evident on its face,
Well,
or because it requires an impossibility from the respondent.
well, but it's not impossible yet. I mean, and well, I guess if I could direct you to 113.55 in the regulations, where it says that notices of violations and orders, including orders to correct, shall be served on the owner, operator, occupant, or other person responsible for the unlawful condition. And here, OAH determined that 4022, because of the warranty of habitability in the DC code and the warranty that went with the sale of the property, saying that 4022 warrants against certain defects in the property for a period of 2 years, that 4022 was the person responsible for the unlawful condition because the property was still under warranty. So issuing the order to correct under the bases that the OAH had to evaluate whether the order itself was correctly issued, nothing that you've stated has demonstrated that based on the statute. I guess, can you direct us to some language in the code or in the regulations that says that they had to join the owners in the order to correct?
There's a provision in the building code at 113.46.
I believe you're looking for 6.
Do you mean the building code or the construction code?
The construction
Okay.
code, 12A DCMR.
Okay.
113.4.6 in subparts 7 and 8 both speak to the requirement to name to advise the owner of its right to appeal in as a mandatory part of the content of the order, and require the district to advise that if the condition is not abated, the district has the right to do so at and perform the work and assess or tax the property owner for the cost of that work and hold it as a lien against property. And that must be included in the order, but obviously cannot apply to a circumstance where the owner is not one of the respondents, at least.
Well, I'm looking at that language now, and it doesn't read to me that this means the owner must be joined as an indispensable party. Here, 40/20/22 began efforts to address the notice to correct in, I guess, in 2021 and 2022. They engaged a engineer who sadly passed away. They showed the potential plans to the owners. So efforts were underway. Those efforts were stayed when the appeal of the notice to correct or order to correct were filed. But it seems to me there may come a time where the record is sufficient to demonstrate that the owners of the property now refuse to cooperate, refuse to allow access, refuse to allow the remediation work to be done. But that point in time, it doesn't seem has yet come.
Well, respectfully, I have to disagree with Your Honor's analysis. The communications dating back to 2021 and 2022 express 4022 LLC's voluntary undertaking to perform this work. And in fact,
Well, it wasn't voluntary because it was pursuant to the order to correct, which had not yet been changed as requested, because the hearing hadn't happened yet.
actually, though, Your Honor, the record shows that there was an initial order to correct that was issued to the owners in August of 2021 that directed the owners to get an assessment of the structural integrity of the
Right, and then
property.
once they did,
Right.
DCMR, now Office of Department of Buildings, determined based on the warranties and other issues that the problem with the property was due to attributable to 40/2022, and then issued the order to correct against
That-
40/2022.
That was their determination, but 4022 had commenced efforts to, commenced its actions, I should say, to obtain a remedial design for the structure in October, on or about October 19th of 2021, prior to the order to correct, and it occurred within a matter of days after receiving a copy of the engineering report saying that there was potentially a structural issue with the property. So I submit that that could only be voluntary. And it was 4 days after the order to correct was issued that Mr.
So haven't you already waived your argument that you're liable under the warranty? You've said on the record that you're liable under the warranty. You said on the record, the reason you made the repairs is because of the warranty. And you're the people who sold the building to the owners. Why are you, that's what you said below. So haven't you already admitted liability on the record below?
But I don't agree, Your Honor, that that constitutes an admission of liability that forms a basis for the order to correct. It is an acknowledgement of warranty obligations, but the question of warranty first is one of contract, and second, it does not automatically follow that the person who is providing the warranty is the one who did the work that caused the problem as required by 12 ADCMR 113.
But isn't that the point? That's what the chief's question was really getting at, and I'm not sure I've had a sufficient answer yet. Isn't this premature? There's been no enforcement at this point. There's been an order of liability. It's akin to a rental management company here in the district, and it manages 7 properties in Northeast DC. There is an order to correct to the rental management company. It has 0 ownership interest in the underlying properties, but the order to correct is issued to rental company management A. They don't appeal that order at that point until there is an enforcement action for failure to comply with the order to correct. And then they could point out that the necessary party, namely the owner of the property, is not properly named. Wouldn't that make more sense than what you've done here, which is appeal without ever allowing the district to actually seek to enforce its order?
Well, no, I don't agree. I understand your understatements, but I don't agree that the LLC did not allow the district to proceed. It's the record is clear that the matter was not docketed for hearing for between a year and a half after the appeal was filed. That's no fault of 4022 LLC, who continued with its own efforts to voluntarily perform these repairs. I would,
But that's the
I
point.
want to make sure I'm
didn't-
answering your
you didn't
question.
seek to, where you weren't doing the work. There was no, the point would have been, if you were doing the work, a stop work order, one of those big red stickers would have been put on the front of the property. If you had been doing the remedial work, then an enforcement action by the district could have been
Right.
initiated. It would have been initiated against you. And at that point, the gravamen of the actual dispute would have been solidified, because at that point, the homeowner would have been served. And as I understand it, the broader point here is that this is premature because no enforcement action on the underlying order to correct has actually begun.
But if work was already being performed or in the midst of being performed at the property, such as a stop work order would issue and the red sign would be posted, that necessarily implies that a permit had already been issued to the person performing the work it implies that the recipient of the order to correct is that there is a possibility because of already being engaged pursuant to a
Well,
permit.
but so then is your argument that if the order to correct had been issued to your client alone and there had been complete cooperation by the owners here from the get-go and process was underway to get permits and everything was hunky-dory, your client would have still had an appeal to OAH to challenge the order to correct? I mean, because that has to be your argument, because your point is that the order to correct was void ab initio because it didn't include the owners, regardless of post hoc developments in cooperation. So even if they had been cooperating, your position must be that you would have had an appeal to OAH at that point. Is that right?
I believe that's accurate, Your Honor, because the order in its current form even had it was void at the time it was issued, because regardless of cooperation or non-cooperation, it puts control of the process. It takes control of the process out of the hands of DCRA, DOB, and puts it in control of the owners whose permission, as OAH expressly found, was necessary in order for the respondent of the order to correct to perform the work. So and there's no precedent. There's no precedent in the District of Columbia for issuing an order to correct to a non-property owner. This is acknowledged in the record by the district as an issue of first impression. And the reason has to be clear, because the non-owner is powerless to do anything under the provisions of the building code. So the same order that references a building code and references alleged non-compliance or non-conformity with the building code in terms of work that was done, the same building code does not allow the respondent to obtain a permit to perform that work, or as was the case here, to be involved in the special inspections program under section 109 of the construction code.
Right, but I mean, the regulations specifically contemplate that these orders to correct can be served on non-owners. Can be served on the owner, operator, occupant, or other person responsible. So it's clearly something that's contemplated under the statutory regulatory scheme here. And the acknowledgement that permits are needed to correct a lot of problems is not unusual. So, and there.
Right, which is why I would submit, Your Honor, that there has never been a case where in order to correct that required a building permit was not also, at minimum, not also directed to the property owners, if not solely directed to the property owners, because there's an inherent problem with the order as a matter of law. And the Department of Buildings has not cited any case for the proposition that the law permits it, that there's any precedent for doing what it's done in this instance.
And when you say as a matter of law, again, you would point us to 113, 4.6. Is there any other statutory or other provision that you would rely on in support of your proposition?
Yes, well, there's an inherent contradiction in the order's directive to perform work and the provisions of, I believe it's 105.3.1 regarding permitting, that provide that only the owner or the owner's authorized agent may apply for a permit. Likewise with the special inspections program that's often involved for projects of any complexity, where I believe it's 109.3.13.1 says that the construction code authorizes the code official to require the owners, and the emphasis is in the original, require the owners, emphasis on owners, to, I'm paraphrasing a bit, but to abide by the requirements of the special inspection program. Only the owners can sign the documents
So
that are necessary. So
was there an effort during the time where you characterize 4022's voluntary efforts? And I take issue with the voluntary word because during a good portion of the time that you reference, the order to correct had been issued. You may have started some of the voluntary work prior to that, but was there a time where 4022 sought to get a permit and the owners blocked it or didn't cooperate with it?
yes, Your Honor, it's in our brief.
Well, I know there were
Yeah.
some negotiations and discussions back and forth, points of disagreement.
Right, well, I would suggest it's a little deeper than that. There came a point in time when the design was approved. That was one of the requirements of the order, obtain a design, and that was approved. It was approved on or about January 26th of 2021. The LLC had already been in communication with Mr. Hader at DCRA, asking whether the LLC could sign the permit in its own name. And it was told, no, it has to be per the code. It must be the owners. A request was made to the owners to please authorize the LLC to obtain the permit as the owner's agent. There was no reply for a period of several weeks. The record also reflects that during that period of time, the owners were meeting with DCRA itself and with city council members, and that Mr. Chopra, then the director of DCRA, on the same day that the permit on the same day that the design was approved, and that was communicated to 4022. Mr. Chopra spoke with the actual property owners and assured them that the property owners had to approve the design, and the property owners could not fire the contractor, but controlled access to the property. So, and subsequent to that, the owners came back to 4022 and said, we'll allow you to do this work, but we will require that you do 68 other items and then additional work on top of that, pardon me. And OAH made factual findings in its final order and this is in the appendix at 9 and 10, that after additional discussions, exchanges of emails and mediation, the parties, and she's referring to 4022 and the owners, could not reach agreement on the conditions for the owners to allow 4022 LLC to get the building permits.
Mr. Crawford, if I can summarize what I think your position is, it's that in order to correct, directed at a non-owner where a permit is required is intrinsically ab initio, legally flawed, because it requires the non-owner to do something they cannot do, and therefore it's arbitrary and capricious.
That's correct, Your Honor.
Okay, so my question is, where does that, and this is an actual question, and I'm probably going to have it for your friends on the other side too. How does that map on to the building code ground for appeal that says the appeal shall specify the specific provisions of the construction codes, et cetera, you know, DCMR 112.2, the specific bases for appealing to OAH from an order to correct.
Well, 4022 took the position with OAH prior to the hearing, at the hearing, and raised the issue with DCRA shortly after the order to correct was issued, that it found itself in an impossible, this was the LLC's communication. It found itself in an impossible position because it was ordered to do something and it was unable to proceed with what it was ordered to do. The LLC filed a motion for summary disposition in 2023, shortly after the matter was referred to the OAH hearing docket, saying that the order was void as a matter of law for purporting to compel the LLC to do something that it was unable to do, and that the provisions of the building code were in inherent conflict with each other as they relate to that order.
So to the extent the regulation requires specification of the provisions of the construction codes that are incorrectly interpreted or applied, would it be the provisions of the construction code that require a permit to do the work? Is that what you pointed to as a basis for appeal under 112.2? That's my question.
Well,
Or is it this just a general arbitrary and capricious challenge that doesn't seem to have a specific reference in the regulations?
Well, I have to make a distinction between what 4022 said in its formal notice of appeal, and I don't know if this is what Your Honor is getting at, where it appealed, disputed the findings, did not cite in the notice of appeal the building code provisions, and the record evidence shows that the LLC never anticipated that it would meet resistance in efforts, and understand the distinction between voluntary and not after the LLC receives the order to correct in December. But so on the one hand, you do have the notice of appeal that does not specifically reference the permit provisions. On the other hand, I believe this is a non-waivable argument as to the validity of the order as a threshold matter.
Yeah, I mean, it wasn't like a trap question.
Yeah, okay.
I really want to know if your theory is that to the extent you're required to comply with 112.2, which requires specification of provisions of the construction codes that were incorrectly interpreted or applied, that would be provisions in the construction code that required your client to get a permit that could not be complied with inherently. Is that your view, or is it your view that you could simply challenge the order to correct in sort of a free floating way, unmoored from 112.2 based on it being arbitrary and capricious?
Well, I believe that the latter is possible. I believe that the initial statement regarding the building code is accurate as to 4022's position, as to which it's been consistent throughout the matter.
Okay,
I know I'm way over my time.
all right. We've reserved some of your rebuttal time as well. Thank you.
Yes, thank you, Your Honor.
Ms. Yellerson, is it?
Thank you, Your Honors, and may it please the court, Tessa Jellerson for the DC Department of Buildings. I'd like to make a few initial sort of framing points here to begin with. The first is what an order to correct is and where we are in the proceedings. An order to correct does not initiate civil enforcement proceedings. It's not a complaint. So we are not at a motion to dismiss stage here. I would say we're even more premature than that. All an order to correct does is serve notice of a code violation. It provides clear step-by-step instructions of how to abate that violation, and it serves as a forcing function to allow for the voluntary abatement of that violation. I would also note that as Judge Schenker, you mentioned, the regulations expressly spell out in section 112.1 an extremely narrow universe of claims that can be raised in a direct appeal of an order to correct, a direct appeal of its validity to OAH before enforcement proceedings kick off. And to make a valid challenge, a cognizable challenge before OAH, the LLC has to point to, quote, specific provisions of the construction codes that have been incorrectly interpreted or applied. Or it could also argue that even though there is a code violation, perhaps they have used some equally good or better form of construction.
Counsel, doesn't it also reference, there's 103.1, which is kind of a catch-all, which says that it speaks to the code official and the intent, reaching the intent of the code is kind of a catch-all provision that could have, it kind of, if it's not specifically delineated, 112. For you to note in your appeal at 112, you could cite to 103.1 such that the code official failed to reach the intent of the actual code. So
I'm not familiar with that, Your Honor, but I would say certainly that's not an argument that has ever been pressed and therefore has been waived by the LLC. That was never raised in any form before OAH, and it was twice forfeited in this court. It was not raised in their opening brief or in their reply brief. And I would say the plain text of section 112.1 makes clear that this is really supposed to be a narrow universe of claims that you can bring before OAH, and for good reason, because an initial appeal of the validity of an order to correct OAH stays the enforcement of the order to correct. So there's good reason why you'd want to have sort of a narrow universe of an appeal that you're dealing with, so that the district is not stayed for too long in enforcing and ensuring compliance with the integrity of the code.
Right, but so, I mean, counsel, your earlier position was in order to correct is kind of a very early stage in the proceeding. It just kind of provides notice of the things that need to be abated. But I mean, you would have to agree that it imposes some detrimental consequences on the receiving party at some level, right? I mean, someone who has received or been served with an order to correct is in a worse position than they were the day before, right?
Your Honor, certainly I can be sympathetic with that. There is the threat of potential enforcement action at some point in time. Just to be clear, it's not as though at this point the LLC is, for example, accruing daily fines for being out of step.
No, but they're subject to this overhanging looming requirement that they engage in some action, right? And so it's fine to say you're not actually harmed until we seek to enforce that, but I don't think, I mean, we don't apply that in analogous situations. I mean, I can't think of specific examples now, but I think it's fair to say that if someone issues something to me that requires me to do something, it's not, I'm not going to just rest easy by hearing them say, don't worry about it until I try to go to court and have it enforced against you. So if we take that as the premise, then we have to assume that the receiving party has some ability to appeal that order to correct, which we do because the regulations spell out certain delineated bases to appeal from it. And I guess my question is, this is similar to the question I posed to your friend on the other side. How do those delineated bases map onto sort of other notions of arbitrary and capricious review, or the general notion, which I think your client seemed to acknowledge below in OAH, that there is some inherent impossibility here, and a party that is required to get permits to comply with the order to correct and is not an owner necessarily cannot comply with the order to correct. So at what point or in what way can the receiving party of an order to correct in that situation seek some sort of review of that order to correct.
Sure, I'll take that question in two parts, if I
There was
may.
many questions.
Yes.
wrapped up, so-
Thank you. Just starting with the latter portion, just to make an initial point. We would strongly contest that as an initial matter on the day the order was issued, it was impossible. In fact, the LLC's representative testified before OAH that on the day he received the order to correct, he believed compliance would be possible. And all of the record evidence that DOB has before it suggests that if the LLC were to submit a workable, approvable plan to the agency today, the owners would be willing to provide
Well, it was
access.
perhaps not impossible as a factual matter at that time, but it was impossible on its face, standing alone. It was impossible.
Well,
Because the baseline at that point is that it's only directed at 4022, or let's take the specific parties out of this, it's only directed at the non-owner, and the non-owner can't get the permit. So standing alone without knowing anything else about cooperation or non-cooperation of the owners, it's impossible.
again, I would strongly disagree, and I think that ties into the first part of your question, Your Honor, if I may. So it's not as though the order to correct says, you LLC go get the permit, because then I agree it would be impossible based on the provisions of the code that say that only an owner can get a permit. And I think this ties into your question, how does this map onto, what specific provisions are being challenged? The only provisions that have ever, and I'll buy it loosely, been invoked by the LLC are the provisions that say that the owner has to get the permit, which there is no dispute as to the interpretation or the application of those provisions. But the LLC has not invoked the provisions that they would actually need to make an argument that DOB does not have authority to issue an order to correct to them or to them without the owners, which are sections 113.1 and 113.5.5, which make clear that DOB has broad authority to penalize any person, and that's 113.1, any person who is engaged in or caused a violation of the code, or 113.5.5, which again says that DOB can serve an order to correct on not only the owner, but any person responsible. And here, I think,
Is appellate counsel's argument is that this is unprecedented? Is this the first time? I mean, I have directed appellate to the language in 113.5.5 that says any other person responsible. So the regs seem to contemplate that persons other than the owners, well, the regs specifically state that persons other than the owners can be served. But has this ever been done before where only the non-owners were served with the notice to correct?
thank you, Your Honor. This is not unprecedented in terms of agency practice. And I can point you to a hypothetical that occurs with some regularity within the district. And that's where one individual performs construction on his work and causes some harm to his neighbor's property in a way that therefore causes a code violation on his neighbor's property. DOB with some frequency then will issue an order to correct to the first party, the constructing party, to ask that they fix the damage they have done to their neighbor's property. And I'm not aware of a court case striking that down as an invalid exercise of DOB's authority. I do know that when it comes to enforcement proceedings, sometimes there can be issues because the neighbor whose property was damaged may not want their neighbor who caused the harm in the first place, for example, to go and do the work. But the point being that if there are troubles with compliance, those are issues for enforcement that are aired in enforcement proceedings. I'm not aware of OAH ever saying that that would be an invalid exercise of authority. I would also say the mere fact that there aren't cases that speak to this is probably more likely due to the fact that this never bubbles up to litigation, because in most circumstances, there is voluntary abatement of the issue, or it may be that grave structural defects like this are identified before a developer has sold the property, such that they are still the owner and this issue is avoided altogether.
We spent a lot of time this morning talking about codes and specificity as it relates to those codes. Why shouldn't we just send this back to the ALJ when they plainly not only quoted the wrong statute, they cited the wrong statute, and they used it as a basis for their decision? And in our decision Moore v. Doe's, it's been our body of law for over 20 years, is that when the agency so misunderstands a material misconception of the law, That is plain error. Why is this not plain error? We should just send it back to the ALJ to start again.
This is not harmless error that requires a remand here, Your Honor, and that's so for a number of reasons.
This is not harmful error that requires it.
Yes, thank you. Thank you, Chief Judge. For starters, the LLC did not raise this issue at all in their opening brief. One would imagine that if this was such a significant issue, that they would raise the issue. Instead, they affirmatively relied on the property maintenance code. I would also say that in terms of the substance, the property maintenance code and the building code are analogous, such that there's no substantial doubt about what the outcome would be if this case were remanded. And in fact, in some ways, the property maintenance code is substantially more lenient. So if they fail to raise a cognizable argument under the property maintenance code, surely they would under the building code as well.
But couldn't the ALJ look at this and say, you know what, you actually need to serve the homeowner here. I'm gonna reverse the order and send it back. Invalidate the order and then send it back. Why wouldn't we want to give her the opportunity to do that?
Well, I think they could have done that in the first instance, but they didn't because as they rightly recognized, the universe of cognizable claims that you can raise are limited, and the
They
LLC.
based that decision on the wrong body of law. It's the wrong statute.
But the wrong body of law that has the same confines, it imposes the same confines on the scope of claims that a litigant can raise, and that would lead to the same outcome as if they had cited the proper provision of the building code. And Your Honor, I can walk you through the provision.
The property maintenance code states an appeal shall be based on a claim that the true intent of this code has been incorrectly interpreted. The provisions of the code do not fully apply, or the requirements of this code are adequately satisfied by other means. And that's 12G DCMR. And that's not, it's not so dissimilar, arguably. And the appellant may disagree if we put the language side to side. 112.2 of the building code says, well, we've already read those provisions, but it says the appeal shall specify the specific provisions of the construction codes or the rules legally adopted thereunder, and that the appeal alleges was incorrectly interpreted or applied and shall provide evidence in support of the allegation.
Correct, Your Honor. And it was for that reason I was attempting to make the point that substantively, these provisions are the same. If anything, the property maintenance code perhaps is slightly more lenient because it doesn't have the language that you have to point to specific provisions of the code that have been misinterpreted or misapplied. Instead, it has this language about the true intent of the code being misinterpreted or misapplied. And again, I would just note this argument that the ALJ relied on the wrong law was forfeited by the LLC. It was mentioned not once in their opening brief. And I also want to go back to some of the initial questions that Judge Schenker, you were pressing with my opponents here. As they noted up on the stand today, they said that even in the most simple case where you have a single developer and they're being asked by DOB to perform work on a single owner's property and there's a permit required, they would say that that is facially impossible from day one, that's an invalid exercise of DOB's authority, and the LLC can simply throw up their hands. They don't even have to make initial efforts to ask for the owner's consent. And I would just say that there's nothing in the regulations that suggests that is the case and that DOB's authority is constrained in that way.
But if you may have answered this earlier, so apologies if you did, but if I mean, I know your argument is that they didn't do this, but if 4022 had filed the appeal to OH for OH review and cited a specific provision in the construction code that required it to obtain a permit before doing this work, would that have been a valid appeal?
Again, I still would say no. Certainly it would be closer. At least they would have cited a specific provision of the code. But again, it's not the provision that requires a permit that's being in any way misinterpreted or misapplied. It's the provisions 113.1 and 113.5.5, which they have never engaged in, not before OAH and really not before this court, that make clear that DOB has authority to serve in order to correct on a non-owner, on a person responsible. So I would say that, so no would be my answer there, Your Honor. And
I'd like to follow up on Judge Schenker's question here. 113.4.6 states that the notices shall inform the owner of the owner's right to appeal. Isn't that a nonsensical explanation? If the code says that the owner has to be served, essentially is getting notice, why would you need to tell a third party of the owner's right to appeal? That doesn't make any sense by the plain language of the code.
Thank you, Your Honor. I would note first as an initial matter, again, that is a provision that has never been raised and has been forfeited before OAH and also before this court in the LLC's opening and reply brief. And again, I would also say that regulations don't normally hide elephants in mouse holes. I don't think the intent of the regulation was to circumvent all of the other language that we have in 113.1 and 113.5.5 that clearly make clear that the intent is that DOB can serve these orders on non-owners. I think the reference to owner there is simply a shorthand reference, but it's certainly not meant to tip upside down the intent of the rest of the regulations. And I would also just as a factual matter, our position is that factual developments that occurred after the issuance of the order are not relevant to its validity on day one. But I would also just push back on some of the arguments that we heard from opposing counsel here today that the homeowners are the obstacle here, or that they have given a flat no to the work being performed here. That's not the evidence the agency has before it. And I would say that if the LLC had ever come to the agency with clear evidence that the owners were the obstacle, there are informal channels of resolving this. The agency would have perhaps taken a different course with the owners. But our understanding today.
What are the formal channels? If we see that there've been some discussion back and forth, no resolution, then things have been stayed pending the outcome of this case. What are the formal next steps if this court were to affirm OAH's determination that the notice to correct was properly issued, order to correct was properly issued? Couldn't 4022 turn around tomorrow and say, look, we've tried, we've been working to get this thing going, and the owners are stonewalling us with all these other 68 requests that aren't related directly to the order to correct. What's their next step? They can then do what? Can they file something, or is the next step on the Department of Buildings?
Well, I would say that if it were actually the case that the LLC had evidence that the owners gave a flat no and were unwilling to work with them, they could come to DOB and communicate that to us.
How? And is there like a procedural mechanism where they can file a notice of messing with our enforcement efforts? I don't know what it.
No, and I understand that Your Honor asked about formal mechanisms, and my first response was more to an informal sort of communication with the agency. In terms of formal steps, I think that the next formal step would be if in fact enforcement proceedings are commenced, and they are commenced in a way that the LLC still takes objection to, meaning that the owners are not joined in those proceedings.
Well, I would say recommenced, because 4022 has commenced some enforcement efforts prior to OAH's determination.
Well, no, Your Honor. DOB issued an order to correct, which is not the initiation of an enforcement proceeding. An enforcement proceeding is a separate independent step that the agency would have to take, where they actually file a complaint in Superior Court.
I guess I was asking about steps that 4022 can take. So essentially, under this regulatory scheme, 4022, if this court affirms the OAH's denial of dismissing the order to correct, 4022 is left in the position, I'm gonna say it this way for purposes of my hypo, at the mercy of Department of Buildings to keep trying to fix this property until Department of Buildings determines that they've tried enough and they're just left to stop. If they feel, look, we've been at this for months, we can't get an agreement, we've had you mediate, they then have to sit and wait until Department of Buildings files an enforcement action against them to offer these defenses that they're trying to get ahead of here.
Or if I could put a finer point on it, if I were 4022, wouldn't I just not do anything now? I mean, your point seems to be that until there's an enforcement mechanism, there's no real onus on them. So on the chief judge's point, shouldn't they just not do anything at this point?
Well, I think that depends very much on what you consider to be the state of play at the moment. And our contention is, again, strongly that the owners are not the obstacle to compliance here. So it's not that the LLC is just at the mercy of DOB. If they really want to shore up their position, they should in fact be cooperating with the owners, as the owners testify that they were willing to do, and submitting a workable and approvable plan to DOB. If it's their belief that they have done everything they can to comply with the order to correct, they can take comfort in the fact that they would have fodder for an impossibility defense that would protect them from being held liable in an enforcement proceeding.
But that's only after they're sued, essentially. It just seems like an odd statutory scheme. And then in the midst of this are the folks swaying in the wind, literally, the owners of the property. So it just seems unclear what the path forward is here. And I mean, there's no dispute that efforts have been made. There was an engineer retained, there was a proposal presented to the owners to fix the property. The damage apparently is not life-threatening, but it's significant enough that it would require the owners to move out, which I imagine is a hardship, but if the property is going to be repaired, it seems like that would need to be done. Who's overseeing all this in the meantime? I mean, it seems like 4022 could potentially go to a lot of expense only to get to a point where there's still no agreement. And then their reward after trying to make those efforts is to be sued in an enforcement action. When they're trying to raise some of those red flags, again, I'm putting their spin on it for purposes of this question statement to you.
Sure.
And you can respond.
Sure. A few points on that, Your Honor. So the first, I want to just assure the court that DOB has and is continuing to take this case extremely seriously. We are in the process of vetting our enforcement strategy, and we are seriously considering exactly how to initiate enforcement proceedings. I also want to just again reiterate that from our view of all of the evidence in the record, the LLC has not acted like you would expect a party who is seriously trying to remedy a very serious structural defect expediently. And I can point you to a few examples of that in the record. First, their appeal before OAH sat undocketed for 15 months. They made absolutely no effort to contact OAH, to nudge the court along, to see what was happening there. They have not, for example, expedited this appeal, which they certainly could have done if they wanted to seek the most expedient resolution. And I think from opposing counsel on the stand here before you today, he mentioned that between the course of January of 2022 to May of 2022, when there was at one point an initial plan that had been tentatively approved by DOB, the owners didn't immediately give their sign off. They came back and asked a few questions, which I think is eminently reasonable, given the fact that the same two parties, DVI and the LLC, who initially created the problem, were the ones who are proposing to fix it. The owners might ask questions like, how is this really going to work? Especially given the fact that, you know, the plans that DOB has of how the building was supposed to be built don't map onto how it was actually built. So the owners were asking questions like, well, this isn't actually the blueprint of the property as it exists. So how will this work? You know, how will you do this? And raised other questions like, you know, can we really trust DVI, the builder who built this initially? I think those are eminently reasonable questions for the owners to take. So for the LLC to say that the owners are the ones who are putting up impossible barriers, I just don't think that's reflected in the record. And I think that if there were any evidence, again, that the owners ever had been or become the obstacle here, then DOB would take enforcement actions against them. Again, we do have the initial August order to correct against them that was issued against them that could be a hook for enforcement proceedings, or they could simply be looped into separate enforcement proceedings alongside the LLC.
So this would be extra record, but is there any update on where things stand now? I mean, the last I saw was that at the OAH hearing, at least one of the owners testified that they were amenable to cooperating? Has anything happened? I know everything's been stayed pending this appeal, but
Sure. My understanding is that again, if the LLC were to submit today a workable, approvable plan, which they have not currently, that can be approved by DOB, that the owners, I expect, would agree to that. I don't have any basis to believe that they would not. Again, the owners are not our clients. I don't know that I'm in position to exactly speak for them. But DOB is simply, the landscape that we have before us, the August order to correct that was issued to the owners and the December order to correct that was issued to DBI and LLC, that reflects the agency's assessment of who should bear the burden of fixing the problems and who is the responsible party at play. That was our assessment of the landscape when we issued those orders, and that continues to be our assessment of the landscape today.
August order issued to the owners was rescinded, revoked, or is it still?
No, Your Honor, it was not. The owners did take some initial steps towards compliance there. They were asked to do a few things. First, obtain the structural assessment, which they did, and also have a sprinkler system review, forgive me.
So have they complied with the second step, the sprinkler system?
DOB hasn't taken, yes, I believe that they have with the sprinkler system, yes.
And the engineer that did, I believe it's the engineer that did the design or proposed design plans for 4022 sadly passed away. And so now a new engineering assessment is needed because the engineer who actually does the assessment has to be available. Has that been obtained by 4022?
Yes, so the LLC did obtain a second engineer who submitted a very different plan. So the first plan was what's called a moment frame, which you can envision as sort of an exoskeleton that shores up the exterior of the building. They were not able to get another engineer to sign on to that plan. They were able to find another engineer who came up with what's called a shear wall plan, which is, constructing parallel walls, 5-foot long walls in the interior of the building that splice up what's now an existing open floor plan into different rooms. And vague concepts of that plan without specifics were submitted to DOB, but not in a way where there are enough details that DOB can actually approve it as submitted. And from there, it's things were at a standstill. At one point, the parties attempted mediation, as the final order from the ALJ reflects. At one point, there was a tentative agreement. But unfortunately, that didn't pan out. And then, of course, the LLC has gone into bankruptcy. So there have been some ripple effects from that as well.
Are there ongoing steps to assess the safety of the owners remaining in the building? I had understood that while these conditions were serious and problematic that caused the building to sway, there's no immediate danger to the health and safety of the owners remaining in the building.
That's correct, Your Honor. DOB has never invoked sections 115 or sections 116, meaning that this is not deemed an unsafe or emergency circumstance, and the owners are in fact still living in the building. But DOB is taking this extraordinarily seriously and is continuing to expend ongoing resources to figure out the best way to get this problem resolved. And we would welcome a speedy resolution of this case also for Your Honors. To help facilitate that. And if Your Honors have no further question, I would just ask that you affirm the ALJ's order below. Thank you.
Thank you. All right, and Mr. Crawford, you have a couple minutes for rebuttal.
Thank you, Your Honor. I have a number of things that I would like to address, so I will move as quickly as I can. If the court is interested as a matter of fact in whether the owners obstructed or inhibited or prevented performance of the work that's at issue in the order to correct, there is an abundance of evidence in the appellate record that includes emails from prior to or contemporaneous with issuance of the order to correct through November of 2022 on into 2023, describing the many times that the LLC said it wants to do this structural work. It asks nothing in return from the owners. It just wants to, without waiver or admission, take this off the board. And it was never able to do so because there were conditions placed upon permission from the owner to
For
obtain
example,
the building permit.
if, there were a number of negotiation discussions indicated and a number of requests in the record from the owners. Which of those requests do you
Well, you can-
think were wholly unreasonable and thwarted the efforts?
I believe the date is February 11 of 2022. I could take the time to look it up and find it for your honor, but it's cited in the brief. And it says it's from the then president of the HOA to Mr. Sushner, former manager of the LLC, that says this is, we will agree, but you have to do these 68 other items identified in our private code inspector's report.
I'm
And this
sorry,
is,
that's from the owner?
that's from the owner to the
4022?
LLC, correct?
Okay,
And
so which of those things were unreasonable in your view?
the demand was essentially to tear down and rebuild the entire building. And it said, these are only, performance of these other 68 items is only one of many conditions that will be placed on our consent to perform the work as outlined in the lawsuit that has been filed against you in Superior Court.
But I mean,
So
is your position would, if the owners had been named in the order to correct, if the owners had been named in the order to correct, wouldn't they still have, or if at least, or maybe have more of an opportunity to say, I mean, it can't be your position that 4022 gets to come in and say, okay, we're gonna fix this problem by putting giant steel columns every 5 feet throughout your condominium and you take it or leave it.
correct, but
Right.
there are mechanisms in place to address that, which is then DCRA, now Department of Buildings oversight of the construction process. It's permitting authority. It's a ability to enforce limitations on what's done or not done. Its ability to require implementation of the special inspections program that calls for a special inspection engineer of record, separate from the project engineer of record, to monitor the project and file mandatory reports and the like. I addressed it in the opening, so at the risk of repetition, section 109 of the construction code speaks only to the owner with respect to that special inspection program. In the midst of this communication, your honor asked opposing counsel a question about, is there any mechanism available for the LLC or generically for a respondent to communicate with the agency? And there is no formal mechanism. There was no formal mechanism. But the record contains at some points daily and for extended periods of time, weekly communications directly between Mr. Whitescarver, the former chief building official, and Mr. Hader in the permitting office, and 4022 LLC and its representatives. The suggestion that the LLC did nothing and that somehow the LLC is responsible for the agency's delay in docketing this case is untenable. The agency was in constant contact. I should say that in the other order. The LLC was in nearly constant contact during this period of time with the agency about the difficulty it was having, and there was no way for it to move forward because it can't get this permit. A couple of clarifications. The August 2021 order to correct issued to the owners does not require the owners to perform any structural work. So an enforcement action on that order to correct, which DOB has said on the record in the hearing, as cited in our briefs, that we are not going to do. We don't want to bring anything against the owners, and we're not going to. But but the suggestion that the August order can be rolled into the December order and enforced jointly to compel these structural repairs
No, I
is
don't,
not accurate.
I guess I didn't understand that to be the point that opposing counsel was making, but.
Well, either way, the next step for the agency vis-a-vis 4022 is an enforcement action for non-compliance. So the LLC is in a position where it's literally not within the LLC's control to take the steps necessary to do the work to comply. And its alternative is to wait and get sued by the Office of the Attorney General in an action for injunctive relief for non-compliance for something that you couldn't do and something that you couldn't secure the agreement of a private third party who's not party to the order to correct. That just, that does not make sense. On pages 13 and 14 of the reply brief, the LLC talks about the fact, this is DOB states that a condominium was constructed in violation of the construction codes. Two parties are at fault. This is not true. The record establishes 4022 acquired the property and that all structural work was complete at that time. And 4022 had no knowledge of any problem with the structural element of the building. It's undisputed that 4022 LLC did not erect, construct, extend, repair, raise, demolish, or otherwise cause work to be performed that related to the structural elements and so forth. That argument and those statements were made in connection with a section on the warranty, but it clearly tracks the language of 103.1 regarding the authority of the code official and what constitutes a violation of the construction code and who can the code official take action against. It was not, like I said, the code provision was not specifically referenced, but the facts and the language of the code was used. The argument was made by 4022 that this is a case of first impression, that there's no precedent for it, and that the agency can't identify any precedent for it. And the agency did not dispute, excuse me, too many agencies involved. The Department of Buildings, the respondent in this case, did not dispute that in their brief. They argued that 4022 has waived a number of issues, which is contrary to the record, but there was certainly nothing about hypotheticals about tall fences and bad neighbors and somebody's recollection of how those circumstances had been handled as a basis for saying there's precedent here in this case to show that this type of action has been taken before. The communications of the District of Columbia officials that are in the record and cited in the brief show that they are aware that there's no precedent for this and that they have and that they had legal concerns about it. I believe I've hit most of what I wanted to say in response. On the issue of the wrong law, saying that something is analogous is not the same as saying, well, a different result would certainly not occur. I would note that with regard to the language, other responsible person, and now I'm proffering to the court. Our Westlaw search did not show that phrase in any jurisdiction or any precedent for it anywhere, including in the District of Columbia. And the only place that that language appears that we could find in a statute is in the District of Columbia. But it's axiomatic that the other responsible person has to be able to do the things that it's being ordered to do. The agency has said it deliberately chose not to issue this order to the owners, and it does not intend to do so. So any suggestion about what possibly might happen in the future is contrary to the positions that they've taken. And I believe that Your Honor's comments about having a choice of either doing what you by definition are not able to do, or doing nothing and awaiting an enforcement action that can carry with it all the attendant risk and damages and fines and penalties and the like, is not a reasonable interpretation of how the agency, how the Department of Buildings or DCRA is intended to act under the law, or what the intent of the building code is. So thank you. If you have anything further, I'd be happy to address it. Otherwise, that's what I have in rebuttal.
All right, thank you.
Thank you.
We'd like to thank both counsel for your briefs and your arguments today, and the matter will be taken under advisement. We stand adjourned. Thank you.